So as of the 1st of May, gone are your fixed terms, okay? So as of the 1st of May, every single assured shorthold tenancy will automatically become periodic on the 1st of May. So at the moment, we are most likely doing tenancies for 6 months because the new tenancy agreement isn't out yet. There isn't a new tenancy agreement in readiness for you to use, so we're still using the old ASTs as we would because the new one's not available. But what I need you to understand is you could sign a 6-month tenancy on the 15th of April, but as of the 1st of May, it's periodic. It's irrelevant. Okay? So every tenancy from the very beginning will be periodic. So what this means is that tenants will be able to leave at any given point from the start of the tenancy, but they will have to give you 2 months' notice. And I'm going to talk to you about the notice period in a minute. So all new tenancies from the 1st of May will be what is now called an APT, an assured periodic tenancy, rather than an AST, which is an assured shorthold tenancy. And all existing tenancies will just automatically convert. You don't have to do anything, nothing will happen, they will just convert. But there is a responsibility of you serving some documents, which I'm going to cover in due course. If the tenancy, let's say the tenancy fixed term expires in July, right? Let's say it expires in July. As of the 1st of May, it doesn't matter what's written into that contract about notice. Because one, you can't serve Section 21 because it's gone. And two, the tenant now needs to give you the lawful notice, which is 2 months. And those 2 months' notice need to be in line with the rental due date. So this is a positive in a way that actually now there is a legal time frame for tenants to give notice, because most landlords think that tenants have to give you 1 month's notice. Some landlords put 2 months' notice in their contract, but it's not lawful. But the legal stance currently is that a tenant needs to give you no notice if he leaves the property at the end of his fixed term and hands you the keys, because he has fulfilled the agreement. It's called fulfillment. He's fulfilled the agreement. In current laws, the moment it goes periodic, so it goes rolling, they then have to give you 1 month's notice. But now in the new law, they're going to have to give you 2 months' notice, and it needs to be in line with the rental period. So what that effectively means for you as landlords, in theory, not in fear, is in theory, you could be looking at 3-month tenancies, because a tenant can move in, give you notice the next day, and that will expire 2 months later after the rental due date. So effectively, the shortest period of time a tenant can lawfully live in your property will be 3 months. Now, in reality, what I want to do to hug you all and say, look, the reality is this: tenants stay longer. Tenants don't want to move every 3 months. And no offence to anybody that lives in Wolverhampton, I do too, but we're not exactly in an area that is going to attract holiday type let people. You know, people in different areas may face problems with this because, for example, down in Cornwall, I always use Cornwall as an example, somebody may pay less to rent a property for 3 months on the private rented sector than they would for a week in a caravan in the summer. Does that make sense what I'm saying? But in reality, in the Midlands, it is very unlikely, unless you're in the HMO world where naturally tenant turnover is greater, I don't think we're going to see a problem. But what I do need you all to understand is it could happen. Some of the things that landlords are doing in those areas that we're talking about is if they're offering furnished accommodation, they're unfurnishing it. Because people aren't going to want to move into a property for 3 months, furnish the whole thing and then move and go somewhere. So they're unfurnishing properties. So that you can't really do that with a HMO, but you know, in apartment blocks and so forth, that's what some people are doing. Now, the notice from your tenant, you can insist in order for it to be lawful, must be in writing. But you cannot dictate the format. They've been really specific here. An email, a text or a letter is acceptable. Okay? So if your tenant texts you the notice in writing, it's an acceptable notice. Now, what I would recommend that you do is acknowledge the notice and give them the procedure of end dates and so forth. Now, if you want to agree a shorter period, and this will become more relevant when we start to talk about how you can evict tenants, then you can agree a shorter notice if you want to, if the tenant agrees. So if the tenant says, well, I can move out in a month, are you happy with that? You can say yes. But you need to make sure that everything that you do moving forward, Everything is documented. This is going to be really, really important. And the good thing here is, but this again is in theory, that if the tenant changes their mind, they can't stay without your consent. But then with my compliance brain on, I think, okay, so they can't stay without our consent, so how do we get them out? Because they're not going to let us go in there and just turf them out. We all know it's not that easy. So there are some things that I don't quite know the logistics of, and as the guidance becomes clearer and we get closer, I'll have more detail on that for you. Now, one of the things we do all need to be mindful of is joint tenancies. Now, most people will do an AST with more than one tenant on what's called joint and several liability. Have you all heard of that? Joint and several liability means that it doesn't matter who pays the rent, you're all responsible. Yeah? And that is the way most of our tenancies are drawn. Now, the challenge here is one tenant gives notice, it ends the tenancy for all of them. So if you rent to sharers or people that, friends that are living together or whatever the case may be, partners that split up, these are some of the things that we've had. One tenant's notice can end for all of them. But the good news here is we can then renegotiate a new contract with the remaining person. And guess what that means, guys? We can increase the rent. Because later when I talk to you, there's problems with rent increases too. They're putting restrictions and stuff in place there. So you can renegotiate a new contract and therefore the rent can be increased, and then you would start again with that party. But you just need to bear these things in mind in the new world. So let's talk about what we need to do in readiness for the 1st of May. So all of you that have tenants in a property, in a tenancy, have to do one of two things. If you have a written tenancy agreement with them, you can just issue what is going to be called, what they've called a government leaflet that should be ready in March for us to review. So between the 1st of May and the 31st of May, you've got 30 days to serve this on your tenants. You have to serve the tenants with a government scheme leaflet. Now, I'm not talking about the How to Rent guide. I'm talking about the leaflet. Now, we will do this for all of our managed landlords, so you don't need to worry about it. It's something that we will do, but it must be served. Now, if any of you have any tenancies that don't have a written contract, and there could be many reasons for that, you could have bought a property that didn't have a contract, but if there isn't a written contract for whatever reason, you have to issue the new written statement. So if you have a written tenancy agreement, you can serve the leaflet. If you don't have a written tenancy agreement, you have to serve the written statement, which is available on the government website and looks like a load of jargon. Now, in reality, what will happen? Because it will be a legal requirement for us now to issue a written statement to every tenancy that we create thereafter the 1st of May. The reality is it will form part of the tenancy agreement. So the written statement will be a part of the tenancy agreement that we create, and therefore it will be included in the tenancy agreement. But for now, in the transition period, those are the rules that you need to follow. There's the dates, and as we've said, this will now be known as an APT. The written statement is a document that the government have created that will form part of tenancy agreements moving forward. So basically, we're going to have the legal requirement to provide every tenant with a written statement as of the 1st of May. It is very likely that that will be part of the tenancy agreement. So moving forward, once we're in the new world and we've got the new tenancy agreement, the written statement element will form part of the tenancy agreement. So there won't be two documents, there'll just be one. But if you have a tenancy at the moment, come the 1st of May, that doesn't have a written agreement, you have to issue the standalone written statement, it's called, and you can get that from the government website. If they're on an existing tenancy, there's no need to do a new tenancy, absolutely no need to do that at all. In fact, you shouldn't do that because you can't enforce them to sign a new tenancy agreement. You should only issue the government scheme leaflet if you've got a tenancy agreement in place. So quite simple. We've just got to serve them the leaflet. But every tenant, Yeah, so if you've got 5 tenants, 2 tenants, 3 tenants, that's how many you serve. If you don't have a written agreement for whatever reason, then you have to upgrade it to issue the new written statement, which still isn't a new tenancy agreement. It's just a document that explains to them the new rules and what the new law is about. There is what's called statutory periodic tenancies and contractual periodic tenancies. And as part of our old term seminars, that's what we were talking about, because that was one of the problems that we faced then. Statutory periodic tenancies is basically where an assured shorthold tenancy didn't have a contractual clause that extended it to go rolling thereafter when the fixed term expired. It would go statutory rolling because statute means law and legally it becomes rolling. But if you put a contractual clause in your contract, it would become contractually periodic and therefore wouldn't be a new tenancy, and it was because of some stupid rules about deposit regs before why it was a big major thing in council tax payments, but that has gone. Now with the APT, they're all going to be contractually periodic, so there's no... Well, they're all going to be statutory periodic, effectively, but they're not going to be a new tenancy every month because they have no end date. So there's no end period. Does that make sense? So they're pretty much rolling from day one. At the moment, they're not using the word serve, actually. Let me just change that, because from a legal point of view, serve means something very different to provide. And what they're saying is we need to provide. So you need to provide it to your tenant either via email or post or by hand. Whichever way you do it, remember, you know what I'm going to say? Document it, have evidence. One of the things, we're not here to talk about this, but gas regulation rules also states that if you've got more than one tenant in a property, you should be sending the gas certificate to all of them to legally comply. So if you've got husband and wife, husband and adult son that's on the tenancy agreement, every tenant must have one individually. So the same with this document. I would like to think that the government is going to provide all of the documentation that we hereby need to comply with their new piece of legislation. What was talked about a few years ago was what was called a model tenancy agreement, and lots of landlords were using that, and that was available on the government website. We steered away from that because it was too favourable to tenants. So I am expecting the government to provide one. Now, for us as an agent, I'm going to do one of two things. I will, of course, review the one that's on the government website because there's going to be certain clauses in there that we need. But I will also seek to our Arla Property Mark, which is our regulator, I will seek to them to see what their version of events are. Just because sometimes you can still have the content that's required in a tenancy agreement, but it's a little bit more favourable. Government tends to favour tenants. And that's why in the model tenancy agreement, for example, I think it was about 2.5 years ago, they stated if you use that tenancy agreement, you had to consider pets. Well, we do now have to consider pets, which I'll talk to you about today again. But that was 2 years ago. We didn't then. But if you use that tenancy agreement, then you did. So yes, I hope so. The government have now got 2 new numbers, right? I always talk about numbers because these are their penalties and these are the things that they go by. At the moment, their current financial penalties are normally £5,000. If you don't do a gas cert, £5,000. If you don't do this, £5,000. It's £5,000. And for repeat offences, it's £30,000. The new numbers for most of the financial penalties under the Renters' Rights Act are £7,000. and £40,000 for repeat offences. But just remember what I've said about the enforcement. And just remember what I've said, because what's not quite clear just yet is failure to do that, will that then stop you from serving Section 8 if you need to? And that's my biggest concern. Because we're losing Section 21. Our only route to possession, guys, is Section 8. So you can't get anything wrong that may affect the use of that in the future. So I'll keep my eyes peeled. At the moment, it says not just a civil penalty of 7k, but it very well could. Across private rented sector legislation, there's a differing in each piece of legislation as to who could be prosecuted. Okay, so I'm just going to give you 2 examples just to make that easily more consumable. The electric safety standards in the private rented sector that came out in 2020, so the need to have an EICR, under law is only landlord liability. The only person that can be prosecuted if you don't have an EICR is the landlord, even if you use an agent. Under the Immigration Act of 2016, if a landlord or an agent was found to be renting to illegal immigrants and be prosecuted, an agent can be prosecuted for that if they are the responsible party. So some bits of legislation allow prosecution of an agent. Other bits of legislation only allow prosecution of the landlord, so it would still be your responsibility. However, if you are using a letting agent to manage your property, a letting agency term should be very clear to state what they do for you on that behalf and what authority they have to act on your behalf. So basically, we will do your electric cert for you under the managed service. We will do this under the managed service. And therefore, if they get it wrong, then you would sue your letting agent for breach of contract and recovery of any of your losses. So what it does to you guys as landlords, if you're using an agent, is I'd be wrong to stand up here and say it removes all of your liability, because that's not the truth. But it limits your liability because there's a third party that is mainly responsible for carrying out the functions. But for example, I said to you all earlier, I have landlords that won't do maintenance. They can't blame us for not doing the repairs if they're later prosecuted, because we as a letting agent only have power to spend up to £250 of a landlord's money without authority. So if a landlord says to me, Dawn, I know there's a gaping hole in the roof, but I'm not fixing it, I can't do anything, my hands are tied. Does that make sense? So it will reduce your liability, but it will not remove it. So that's why I always say choosing a good letting agent is key. And a good letting agent isn't one that looks pretty. It isn't one that's got the best offices. It isn't one that, you might get on with. It's one that knows what they're doing and will keep you safe. So I always say, if you want to choose a letting agent, ask to see how they operate, where do they store the documents, what's your processes, what's your procedures, who's looking after the property, is it just 3 of you working in an office managing 500 properties, and find out about what that agent is. Because the one thing that I will say, there's multiple letting agents in Wolverhampton, but not every one of us are the same.